So of course, if you are going to use data that you may not even necessarily have the right to use to train your AI, naturally that act in itself may be a copyright infringement.
You're listening to the Legal Insight podcast by HHQ, where we help you make sense of the world of law, business, and tech. Today, we're about to take a deep dive into our recently published article titled Addressing Copyright Infringement and Challenges in AI Training, together with our technology practice group heads, Ong Johnson and Khai.
Generative AI is no longer a new thing to most of us. In fact, it's an ongoing phenomenon that's been ongoing since November 2022, the launch of ChatGPT. In fact, my 70-year-old aunt now uses ChatGPT to do her Bible school homework. So there's no question that, Gen AI is extremely powerful. Now, with this great power comes great inherent risks as well, and it's up to us to manage them responsibly. Johnson, do kick us off. Have you seen more and more clients adopting generative AI lately? Or have they been kind of taking a wait-and-see approach, taking a more cautious stance now?
I think the answer is definitely resounding yes. So basically, based on all the companies and all the clients that we are currently speaking to. So basically, right now, I think AI is more than a trend. So I think that there are many reports that are actually saying that without even implementing AI, it's actually going to affect the share price of a company. That's why I think that you are able to see, especially in the US, a lot of companies, they are really trying to squeeze out everything out from the AI. So basically right now, a lot of companies, they are really putting a lot of effort to implement AI within the organization. But at the same time, I think that a lot of companies, they are also trying to understand what is the benefit of AI, because AI is not free. So basically, in order for any company to implement AI, substantial amount of resources, energy, and money will need to be invested by the company itself. So it's very important for the company to also understand what is the benefit, at least what is the monetary benefit of AI. So I think that for companies, there are actually two camps. The first one is yes, AI is important, and then if I implement AI, it's going to increase my share price, and then it's going to increase the effectiveness and productiveness of my company. The second camp of the company look, AI is good, AI is a trend, but why should I invest that much of money within AI? How does it actually benefit me? So I think that the clients that we are seeing, yes, 100%, they would like to implement AI, but at the same time, they are very cost conscious. They would like to know what is the actual monetary benefit that can actually be brought by AI.
So with so many companies actually preparing their war chest or have already prepared their war chest to pump into, using AI for their business, in their business, why should they be worried about copyright infringement issues? Why should we address these concerns?
Of course. So basically, as I mentioned, so a lot of time when we speak to our clients, they actually say that, look, I want to implement AI. I'm training my own AI. So I think that in order for us to really appreciate these questions, is for us to first understand what is AI, or in other words, how should a company train AI? Contrary to the common belief, a lot of common public, they have this perspective thinking that AI has the ability to generate its own intelligence, but it doesn't. So basically, just think AI as a human brain with different layers of neural networks. It has to be fed, it has to be trained with the right data. So that's why there's a common saying, garbage in, garbage out. So it means that if I'm going to train the AI with a very low quality data, what is going to happen is, no matter how I train it, the outcome of the AI is going to be poor as well. So this is why for AI company, in order for them to in order for them to generate a high quality AI system, they will require a huge amount of high quality data. And how are they supposed to get high quality data? Surprisingly or not surprisingly, a lot of companies, they actually resort to the internet. The common practice is called as scrapping. So basically, they're just scrapping the internet and then getting a lot of free data from the internet. And these actions will lead to something we call as copyright infringement. And copyright infringement is a very serious issue. The reason is because it is more than a legal concern. But when the creator themselves, they feel that their work itself can be easily exploited by AI companies, they will lose the motivation to actually putting in the hard work to produce good quality data. And as I mentioned, without good data, AI companies are not able to train their AI. And this will definitely going to undermine the whole ecosystem.
That's kind of like a chicken and egg situation.
Yes, that's right.
Like you want good quality eggs, you must have a good quality chicken. And if you're not protecting the rights of the chicken, right, it's not going to want to lay good eggs.
Yes.
Yeah.
Yeah. So Khai, maybe you can explain to us like what copyrighted work actually is and how can it be protected under the law?
Before we can even talk about copyright infringement, we need to first understand what are copyrighted work, right? Because if there's no copyrighted work, there is no copyright infringement. Under the copyright legislations of most countries, right, work created are automatically given copyright, provided that, of course, the work is original in itself, meaning that the author who has created the work did not actually copy that work from somewhere. And it's really a work that is created based on the individual's own creativity and originality, right? And number two, on top of originality, there also needs to be some level of effort. In fact, a substantial amount of effort, right, in creating the work. If a work that is created doesn't require a lot of effort, then typically it wouldn't suffice to be qualified as a copyrighted work under the laws of most countries. So naturally, as long as a piece of work, a literary work or musical work or an artistic work, for example, so long as it fulfills that originality and the substantial effort criteria, and there are other more nuanced criteria, of course, to be fulfilled, right? Like say, the author must be a qualified person, it must be created under the jurisdictions of certain countries, for example. Naturally, the work that is created will be given, or rather will be eligible for copyright protection. So essentially, what does that mean to an author per se? A person that is vested with the ownership of the copyrighted work, just like the name itself, copyright. It means that the author actually has a right to control how the work is to be copied. And when it comes to commercializing any of the written work or artistic work, right? Commercializing typically involves copying of the work, be it distribution, be it reproductions, be it printing, publication, disseminations to the public, communication to the public, or rather broadcasting, right? All these actions, all this commercializations activity requires copying of the underlying work. So essentially, a copyright owner has the right to control how and when and under what terms their work can be copied. So essentially, to sum it all up, that's the right of a copyright owner in respect of their copyrighted work.
So Johnson, you mentioned that there are some notable copyright infringement suits against AI creators, who are taking perhaps work that may be copyrighted. You can share some examples on those cases.
Of course. So basically, right now, as long as you just go to a phone and then just do a very quick Google search, you are able to actually find plenty of cases where the authors and the companies, they are really suing AI companies for saying that, look, you are taking my work, you are taking my data to train your AI without my consent. So I think that they are actually one or two extremely prominent cases. They're actually online now. The first one is by New York Times. So right now, New York Times, they are literally suing OpenAI. Basically, the claim is very straightforward. They are saying that OpenAI is using millions of its articles to train their AI without their consent. Another very good example is actually by the very famous author, George R.R. Martin. I'm sure that you're well aware of this author is. So basically right now, he is also making the same allegations by suing OpenAI. The claim is very clear. He is actually suing OpenAI stating that, look, you are using my work to train your AI without my consent. So basically, these cases, I think that most of the lawyers right now, we are actually paying a lot of attention to these cases because eventually the impact of these cases will be set either as a precedent or a very valuable reference depending on the jurisdictions.
And these are ongoing cases or have they been concluded already?
So basically, I think most of the cases is only found last year. I mean, first of all, I think that it's important for us to acknowledge that basically ChatGPT is only in this world in 2022. Basically, most of the cases is actually found last year, which is 2023. So a lot of time, the cases are still ongoing. So right now, from what we understood, is that the common defense actually being put forth by the AI company is that they call it as a fair use, or another country will call it as fair dealing.
Understand. So it sounds like the law is still developing as we speak.
Yeah.
So Khai, maybe you can run us down, like how can a company currently already using AI protect themselves from, these potential lawsuits. Companies that may not be as huge as Microsoft or New York Times, but they want to protect themselves at the same time remain competitive.
Yeah. I think companies, while waiting for decisions and some form of finality, right, to those lawsuits that is currently ongoing, the first thing that they should do is, if they want to deploy their own AI, if they want to create their own AI model, they want to train their AI, for example, they need to first pay particular attention to this concept called data provenance. Essentially, what it means is the origin of your data that you are using to train your AI. Johnson said rubbish in, rubbish out just now. So of course, if you are going to use data that you may not even necessarily have the right to use to train your AI, naturally that act in itself may be a copyright infringement. We don't know. We are still waiting for cases surrounding that issue to be resolved, right? But I think company can steer clear of the ambiguity. They can try to use their own data, limit the data sets that they use to train their own AI model, perhaps to their own data. Or they could go to a third-party source, for example, and get a license rights to use those data. That way, you have a very clear idea of the origin of your data, and you are able to control, right? You only use data that you have the right to use to train your AI model. That way, you really steer clear on a lot of the ambiguity and a lot of the risk. Number two, when it comes to data provenance as well, I think you need to also understand, if you're using your own data, the data that you use may have sensitive information or trade secrets or confidential information about your own organizations, about your own company, right? And also it may have personal data of data subjects that you may have collated or collected over the years and processed over the years. Naturally, you wouldn't want all this sensitive information to be fed into your AI model, because that would obviously leak your confidential information that gives your company a commercial advantage, right? And at the same time, you would also be breaching GDPR or PDPA, personal data protections laws. So it's very important. At the same time, if you are using your own data to train your AI model, look at those data sets to make sure that if they have personal data, anonymize them. If they have sensitive information, make sure you exclude them. Run a filter, right? Filter out all these things. So that's data provenance. Second point that I think companies should pay attention to is commerciality. So when it comes to a copyright infringement lawsuit, typically defense that will be used by a company that is being sued would be fair dealing or fair use defense, meaning that whatever activity that they are using the copyrighted work for is actually fair. It doesn't infringe upon, or it doesn't actually undermine the rights of the copyright owner. And typically, I'm saying typically, I'm not saying that all the time, right? Typically, for a fair use dealing defense to stand, commerciality, whether the company is collecting or rather generating revenue from those activities, would be a very key considerations. So if you are using data sets that you don't have the rights to use to generate profit, so I think chances are for you to be able to rely on a fair use dealing defense would be difficult. So these are the two things, right? Data provenance and commerciality. The 2 points that I think companies should pay attention to if they want to deploy their own AI model while waiting for the lawsuits to be resolved.
Just to add on, so basically a lot of time when we advise our clients, when they ask us, look, I actually want to train my own AI. So basically, what are the things or what are the simple steps that you could actually advocate for? So we always tell our clients, so basically they are just simple, the rule of thumbs, basically they are just 3 steps. First of all, like what Khai mentioned, where are you getting your data? If you're not able to answer that questions, there's a very big issue for you to consider where you're getting your data. Second thing is, how are you processing the data? So basically, when you are going to process the data, have you ensured that you have done the data filtration part? Have you actually filtered all the harmful content? The last part also mentioned by Khai, how are you going to commercialize your AI? So basically, I think that for those that are listening or for companies, they have a great interest of developing their own AI. The simple rule of thumb is, where are you getting your data? How are you processing your data? And how are you commercializing your AI? By considering these 3 issues, we think that the chances of you getting into trouble will be greatly mitigated.
So for those companies who are like Yeah, I hear you, but I'm gonna run fast. I'm gonna break some things. But if those risks are not mitigated and not managed, are there consequences that are irreparable? Are there consequences that people should be aware of?
Of course, I mean we are a firm believer that the consequences are actually way bigger than just legal consequence. Of course, for companies they may be thinking, look, I'm rich, so basically, so what? Copyright infringement, you sue me, and then I have enough money to actually fight the case for years in court. So basically, I think that there is a very surface kind of thinking. The first layer is, of course, when there is copyright infringement suits, the company would need to spend substantial amount of energy, resources, and also money in order for them to actually fight the battle in court. And then this is actually what most companies are just thinking. Another aspect to it is actually the reputational consequence. So basically right now, most companies in this market, trust is everything. Companies are spending years in order for them to develop the trust with the customer, with the clients, with the users. So the moment the trust has disappeared, basically all the works, all the efforts invested in developing those kind of trust will disappear within a day. So basically, this is why a company should actually think more than the legal suits, but the trust that they actually have developed with the client, with the users. And the last part, which we believe is the most important part, is actually it is going to undermine the whole ecosystem. Because as we mentioned earlier, so basically for AI company, in order for them to train the AI, they need data. It means that the data creator, if they felt that their rights are not being protected, if they felt that their data, their work could be easily exploited by the big AI companies, what are they going to do? They are just going to be discouraged. Then they won't continue putting the effort to produce good data. And as I mentioned, without good data, AI company are just simply not possible to produce good AI. So basically, this is more than just a simple copyright infringement. This has far-reaching, wide-reaching effect of undermining the whole ecosystem.
I think to add on to that very quickly, there is also a layer of operational implication as well, right? When you are assuming that an AI company gets a copyright infringement lawsuit and they somehow have an injunctions against them saying that they can no longer commercialize their product. So now what? To untrain an AI model is close to impossible, right? Due to technical reasons. So now if they want to continue their business model of being a generative AI company, they need to retrain the AI model. That's money down the drain. That's time down the drain. That's resources down the drain. So I think company also need to understand that there's always that what if, right? At the end of the day. So I think essentially what companies should do, right? Especially for those companies that are looking to venture into this space, venture into providing generative AI solutions or rather AI solutions, they should first think about education, right? Educate your stakeholders, educate management personnel on the do's and don'ts. What are the current legal landscape? What are the things that they can do to navigate around the legal landscape? It is very important to know what are the regulatory landscape so that you know what to steer clear of. And how you do that, how you do education's plenty of ways. You can have in-house training, you can have in-house seminar, you can also invite external speakers, you can work with professionals, you can work with lawyers, you can work with thought leaders, right? I think lawyers are very well positioned to educate companies of what are the current legal landscape and what are the current legal trends. So once a company have a very good understanding of the boundary or the sandbox that they could play within, then the risk of them getting into trouble, I think it's very much mitigated.
Thanks for joining us, Johnson and Khai. We believe that as AI continues to evolve, it's crucial for our listeners out there, businesses in Malaysia, overseas, to continue to stay informed and stay updated on the latest legal implications. So that concludes our episode. Thank you for joining us for the Legal Insight by HHQ. If you found this content helpful, please show your support by rating, reviewing, subscribing, and sharing this podcast wherever you're listening. Tune in next episode for more thought-provoking discussions on the intersections of law and technology. Until then, stay informed and stay updated.